Welcome to Building Your Legacy, Southern Arizona Estate Planning with Allison Manning.
Hey everyone, welcome back to an all-new episode of Building Your Legacy in Southern Arizona with attorney Allison Manning. I am your host, Mike Leon. You think a will is all you need? Well, I'm here to tell you, think again. Well, actually, Allison's here to tell you. She's the lawyer. But from navigating Arizona's probate and the AUTEX system to protecting your kids with the right trust, Allison's here to break down all the legal tools that are going to help you actually get that true peace of mind for you and your family. Allison, it's good to see you as always. Today's episode, we're going to talk a little bit about how the estate planning can really reduce the stress for loved ones. So I'm sure you get these stories. You get families, they're searching through shoeboxes for wills. I was looking through a shoebox the other day for my birth certificate, life insurance policies. Like, how does having a comprehensive estate plan readily available too, by the way, how does it eliminate all of this detective work for the grieving families out there?
Thanks for having me, Mike. Yeah, it's very important to have an estate plan put together in one place to help alleviate that searching for assets. The estate plan, when you put it together, you'll have your will, your trust, your healthcare documents, your financial power of attorney, and you have them located in one spot. This allows for family members to know I can just grab the blue binder and go handle affairs for my family member. It also gives them the peace of mind knowing that it's all taken care of and that instruction sheet there so that clients can just move forward at a time of need. At a time when you're having to deal with a loss or someone who's ill and needing to step in, you're not needing to shuffle through paperwork. You need to know that you can just grab one thing and handle it, or reach out to an attorney and say, okay, you're my client, you're my parent's attorney. Can you help me through this situation? Tell me what to do next.
Allison, that's the easy path, right? Having everything in preparation. Let's talk about the hard path for a second. So let's say someone passes away, unfortunately, they haven't done any of this. What are the first few days like for the family? And like, from a legal perspective, who's actually allowed to talk to, whether it be, let's say, the hospital, the funeral home, the bank? Like, how does that work?
So you're right. This is the hard path if we don't do any kind of planning. Who's allowed to talk to a bank? Well, if it's your parent who passes away, the bank can't give you any information if the bank account was solely in your parent's name. So until you go through that probate process and get named on as the personal representative in order to make decisions, you don't have the authority to actually communicate and get information from financial institutions. As far as making healthcare decisions, Arizona statute sets out that the next of kin is the one who's entitled to do that. So if there's multiple children around, all of those children are the ones who have to come forward and sign off on that funeral plan or make those medical decisions to end life-sustaining treatment decisions. And oftentimes that's not ideal. Sometimes there's family members not in town or around that are able to make those. Or you may have family members that have differing opinions. One who says, no, keep mom alive forever. And the other one's like, it's time to let her go. And then the family members have no clear decision on which direction to go.
Let's say someone actually did set up a will or a trust. Somehow it got missed that they didn't name an executor or a trustee. How does the family then decide who's actually leading, who's calling the shots? And doesn't that create a huge rift that's going to happen between siblings?
Yes, that would create a big rift in having to decide that. You know, I don't know, if someone drafted a will and they did one themselves would probably be the time, or the trust, those self-drafted documents, that would be the time where they don't name a successor trustee. Typically, it would fall into the majority of the beneficiaries to step in and do something. We may have to get a court involved in order to designate who's in charge and make it clear that that is the successor trustee if there's no authorized path of who that person is. But it tends to be the loudest person. It may not be the right person. It's going to be the squeaky wheel, the one that wants to step in and do stuff. And that's not always the right person to step up in that situation.
Yeah. I think you're talking to that loud person, squeaky wheel. Allison, let me ask you, beyond obviously, the emotional toll that's going through all of this, there is a toll in terms of Arizona probate, and it's a long process. Can you talk a little bit about how you want to avoid that lengthy court process? Because it's a public court process. I think a lot of people don't understand that part of probate.
Absolutely. So the emotional toll in the process is that just having things unresolved and uncertain, trying to determine where all the assets are at can be a long process because you have to reach out to different financial institutions after finding bank statements to determine is there even an account or an asset there. In addition, you have maybe family members who are possibly could use that money in the meantime, but that money can't be distributed till we determine are all the creditors paid and has everything been settled before we pass the assets out to the beneficiaries. And in addition, if there are personal items that maybe want to be passed down, those items are things that weren't addressed if somebody doesn't have a proper plan. And those items sometimes don't go to the right people. It's the ones who show up and start just taking things. And so without having that proper plan in place, the proper person designated to secure the assets, people get hurt feelings. And that's when family divides become even larger, as opposed to having a death be the catalyst to bring your family closer together.
Oh, I know all about that. Someone showing up out of nowhere. Allison, I want to leave that there. I want to go back to something you just said about the bank account stuff, because you said banks won't, let the kids, if the parents only had the accounts in their name. In that instance, though, how do the kids, let's just say as an example, how do the kids pay for the mortgage, the funeral, while everything's kind of frozen by the bank?
That can be a difficult situation for many family members, where and how to pay for it. Oftentimes, it falls on the children to throw down their credit card or to reach into their bank account to pay and hope that there's money after all expenses, that there's money there to reimburse themselves later on. Some family members will allocate maybe a small account where they'll put the child who they know is going to be responsible onto that account. There is some caution with that, but that does give some easy access to a bank account for some money to be transferred quickly to help pay those bills. It's important to talk with clients to find out, do your kids have resources? Are they going to be able to have money? Or when those accounts get frozen in that time period, how are things going to get paid? Because things can just get frozen until someone is allocated by the courts as that personal representative and those accounts get unfrozen for them to access it. So we can talk with clients about making sure there's a fund or an account set up in a way that a child can get access to money quickly in order to pay those necessary expenses.
Allison, we've been talking about a little bit of family drama here. Obviously, someone's passed away, emotions are high. And I'm sure you've seen this where a family member's maybe been left out of all of this with respect to the will and things like that. How can you talk a little bit about how a will contest works, and is it a stressful legal battle for that person?
Absolutely, it's stressful. How you leave someone out is important. So the documents need to acknowledge the existence of this child that you want to leave out and intentionally exclude them from your estate plan. You don't want to just forget to mention them in your plan, and so that is the number one step in trying to ensure that your wishes are honored by excluding that child. In addition, you want to make sure that let's say there's two children, one's getting excluded and the other one's getting everything. You want to make sure the one who's getting everything isn't the one that's driving the car to the appointment, isn't the one that's sitting next to you in your attorney's office. You want to make sure that you have an ability to consult with your attorney without that child present. So that way there's no claims of undue influence or any type of elder abuse situation. And a proper estate planning attorney will want to document their notes as to this, that this was the wishes of the testator or the trustor, that they wanted to exclude their child. In addition, there should be a no contest clause within their documents that will state that if anyone challenges it, that they can be charged with the fees for the challenge, or they can be excluded completely from the estate plan as if they were predeceased. There are some important ways of drafting those documents. And if possible, giving a reason why they're excluded to the attorney so that the attorney can have those in their notes. And additionally, I would say doing this further out from your death is important rather than on your deathbed, when again, challenges can show you were unduly influenced, you were on pain medication, possibly you didn't understand what you were doing at the time. So those challenges are, the burden first is on the person trying to challenge this exclusion. But if they show there was undue influence or some wrongdoing, then the burden switches to the child you wanted the assets left to show that there was none of that and that it was really of their free will. And so, again, meeting with an attorney prior to those types of exclusions so that documents are properly drafted and that you meet with them regularly to say, yes, 2 years later, after I drafted this, I still want to exclude that child. That child is not included in my estate plan. This will alleviate the problems for your other child who's receiving all your assets because it will clearly show that that was your intention and that there was not a mistake or undue influence.
Allison, let me ask real quick because I should have led with this, but what have you seen in your experience that has generally caused the biggest family fights in all of this? You mentioned a couple of things before, but and how do we do a little bit more of the proactive instead of reactive dance and stop these arguments before they start up?
That's a great question. In most of the time, from what I have seen with clients that are going through administration after their parents have passed away and someone is causing problems or beginning to have feuds, most of the time it's because of hurt feelings. It's because of misinformation or a situation where one client, I had one client who told his daughter that she was in charge of the estate when he passed away. And actually, he made his son the executor of the estate and never told her. And here she had been caring for him day in, day out, and then felt very hurt because she felt that he didn't trust her in administering the estate. That lack of information caused a problem that would not have existed had she been acting under the correct information. So those types of situations can be avoided by communication. Some situations aren't appropriate to share all that information with your loved ones before you pass away. But if possible, I encourage my clients to come in with their family members and discuss why they're leaving certain children in charge and why they're leaving the assets the way they're leaving their assets. Again, it's not always appropriate, but if it is a good situation, that can really help diffuse some problems before you pass away, because children then are aware of the situation and what will happen. Additionally, some other things are really with those tangible personal property. You may think, oh, this old thing, it's not worth very much. Who really wants it? But jewelry such as wedding rings, family Bibles, maybe antique cars, things that have memories tied to them, those items are things that it's helpful if you specifically leave them to one child or another. That way that they're not having to fight over who gets those one and only items.
Yeah. Well, Allison, as we kind of put a bow on this episode, I would love for you to reemphasize some of these things. But for someone that's listening to this right now and they don't have a plan or they don't have a roadmap, like you like to say, talk a little bit about why they should start talking with their family. What's the first thing you would advise them to start doing today?
Definitely talk with your family, but get some legal advice. Come in, talk with me, find out what's the right method to approaching the children, depending on the type of estate you have and how you want to leave it. Communication is definitely key for avoiding a lot of problems later on, both verbal communication and correct written communication. So making sure you have a properly drafted estate plan that's going to hold up and that covers the issues and the concerns that you have.
Yeah. It's great advice as always. Allison, thank you for the time and the insights. I appreciate it.
Thank you, Mike.
And that's it for today's episode of Building Your Legacy in Southern Arizona. If you're ready to start that planning, do me a favor. You heard her say it, but visit AllisonManningLaw.com to connect with Allison and the team and start that custom estate plan that's going to protect you and your family's future. Do me one more favor. As always, hit like, hit subscribe, leave a review, comment, share the episode with someone who hasn't started that estate plan today. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.